Well, hello everyone. Welcome back to corporations. I don't think any of us thought we'd be going through classes like this, but here we are. I hope everyone was able to get back from wherever they were traveling to during the break, and that everyone is staying safe. What we're going to do the next few weeks is we're going to present lectures. I'll present lectures through PowerPoint with these recorded overlay that will accompany the slides. One thing that we do in the CLE, the continuing legal education world, is when we have these sort of self-study tools that we use, we implant a series of letters or numbers throughout the presentation just to make sure people have actually watched it or listened to it. And in this case, you'll need to watch it and listen to it because at the end of each lecture, I'll ask you to send me by email the 4-character code that I'll give you during the talk. Again, this is just to kind of make sure that everybody is actually paying attention to it. I know that we rely on you folks to comply with the honor code and to do the work that's actually handed out. I don't know what your other professors are doing, but I'm sure you're appreciating the fact that this is uncharted water for most of us. So we're trying to make the best of it and deliver the same information that we said we'd deliver at the beginning of the semester. You'll see in the revised syllabus I sent around that we are in fact not extending the school year. That was a decision that the faculty made. We're going to keep to the original end date for the semester, but as a result, I've cut out a couple of sessions that'll allow us to get down to that time frame. So make sure you look at the updated syllabus because it does change the timing and the content of some of the classes from now until the end of the semester. What else can I tell you? I hope you've been reading your email from the law school. They've provided a ton of material and resources for you folks regarding the library, academic work, any other service that you might need in this time of relative crisis. I hope you take advantage of that. All that being said, I'm confident that we're going to get through this. We will get through this. It's just a major inconvenience in the relative short term. So we're all going to do fine, but it is a little different to operate this way. I continue to have availability to anybody through email or phone or text if anything comes up, and I expect it will, in terms of clarifying anything that I'm teaching on or anything else associated with the class. So please don't hesitate to reach out to me at any time regarding anything that we're covering during this semester. Okay, enough for the commercial. I wanted to start to talk about today's topic, which is transactions in shares. This is a pretty significant chapter, and we have a hypo on this on Thursday. So we're going to cover a lot of material in this session. It's all also in the textbook, which I'll reference. Let's jump into it. Issuance of shares essentially is the essence of a corporation. That's the whole reason we form them. Aside from protecting ourselves from personal liability, it's also to be able to divide up ownership interests in companies. And in that sense, it's kind of the essence of what a corporation is. This next chapter talks about what happens when the information related to trading in shares is disrupted through a number of different ways. And we'll get into those rules one by one. We start out with Section 10B of the Securities Exchange Act of 1934. And we've looked at that a little bit briefly before. It says that it shall be unlawful for any person, directly or indirectly, by the use of any means or instrumentality of interstate commerce, or of the mails, or of any facility of any national securities exchange, to use or employ in connection with the purchase or sale of any security registered on the National Securities Exchange or any security not so registered, any manipulative or deceptive device or contrivance in contravention of such rules and regulations as the Commission may prescribe as necessary or appropriate in the public interest for the protection of investors. I've said before, and we've seen this in some of the cases, this is described as the most famous rule in securities law and probably in all of business law. And you'll recall that there was also a more specific rule that's promulgated under Section 10B of the Securities Exchange Act. If you look at Rule 10b-5 itself, it's the more detailed expression of the general rule in 10b of the Act. And you'll notice a few things that are significant. It's triggered by any means or instrumentality of interstate commerce. That could be mail, that could be internet, that could be any kind of telecommunication, or regular mail. Also note that it involves possibly the facilities of a national securities exchange. When we get to the actual key points, I want to emphasize any device, scheme, or artifice to defraud. We'll see when we get into the cases. This requires a certain amount of scienter on the part of the alleged wrongdoer. We'll see how that plays out in some of the cases, but that's an important little piece of text from the rule. Also, it talks about in Section B, it's not just making a true statement that's false when you make it, it's omitting to make a statement that leaves out something material that would have made other statements true. So it's statements and omissions. Important factor there. And then the third point, they have the general anti-fraud or deception language in subsection C, which again can be broadly construed. As a result, this ends up being the statute of choice for all securities fraud or securities manipulation cases, and we'll see it in every one of the complaints and every one of the cases that we're going to talk about. So where does this all start? Remember, we talked a little bit before about the Federal Securities Acts, the 33 Act and the 34 Act. We talked a little bit about the history of all this in the stock market crash. We talked about this in week 3, and the fact that the stock market crashed because there was unregulated hype. There were hucksters, snake oil salesmen making false representations regarding the value of their companies and therefore the value of the shares in their companies. And there was a real inability for investors to get a true picture of the fundamentals of a company because disclosure wasn't really regulated the way it is now. People made statements that were false and misleading, thus the need for the federal laws. The state securities laws, as we know, exist in parallel with federal securities laws, and there are 50 versions of them, all of which have been in various states of development since 1933, and whereas they're all similar in a lot of ways, they are actually have minor differences between them. And this has been part of the landscape as well that's led to what we're talking about today. The basic federal statutes, the less developed state securities laws that sometimes piggyback on the federal statutes. At the beginning of the enactment of the 33 Act and the 34 Act, there was not a lot of jurisprudence beyond the literal statutory construction derived from reading those statutes themselves. The first case we have to look at is the Carden versus National Gypsum case from 1947, U.S. District Court case that basically held that the existence of a private cause of action remedy is implicit under general principles of the federal securities laws. In that case, the remedy was rescission of a purchase of securities. Why do we care? Why is it important? Why do we even have this case? The reason we have the case is to give us an idea of how this law developed from the beginning. The law had been in place for, what, 12 years, 13 years before it was decided that there was an actual civil cause of action for violating these laws, that they weren't just enforcement tools for federal prosecutors. This is important because now we have the ability for what we call private attorneys general, essentially the concept that private citizens can enact these statutes for the good of everybody, really. They're deputized, as it were, under this type of a decision to enforce these laws in a private context. That's why the case was significant. That's why we have it. You'll see in that case, the dissent had a fairly strong argument. They said that by the majority construing 10b-5 so broadly, quote, sweeping prohibition against fraud, when this results in rendering nullities of the other anti-fraud provisions of more limited scope, which can be found in the statute books. What was the dissent getting at? What they're getting at here was the idea that 10b-5 would eventually eclipse all of the, quote, lesser, quote, anti-fraud laws. For instance, proxy rules, perhaps regular state anti-fraud provisions. As familiarity with the law grew, however, litigants have come to prefer federal jurisdiction for these types of cases. Federal discovery rules, service of process, broad coverage under Section 3A17, that's the intrastate use of any interstate communication systems, mail or telephone, for instance. The next case I want to look at is a U.S. Supreme Court case from 1975, and I'm looking at the blue chip stamps versus Manor Drugstores case. Again, this is part of the development of the jurisprudence regarding this fundamental statute of 10b and Rule 10b-5. What's going on here? What's the case about? We don't have a lot of facts, but we do have enough facts to see that the plaintiff was filing under 10b-5 based on the fact that they were offered shares, and the plaintiff basically says that I could have been defrauded, I might have been defrauded, I was essentially an offeree of the securities, not the purchaser. We think that this particular plaintiff thinks that we should expand 10b-5 not just to cover buyers, but also would-be buyers and offerees. The court, of course, rejects this expansion of 10b-5 liability to offerees. And they cited the Burnham versus Newport Steel case from the Second Circuit that had already held that 10b-5 relief was only for purchasers. And the court says, quote, when we deal with private actions under 10b-5, that means civil suits brought by individuals, we deal with a judicial oak which has grown from little more than a legislative acorn. Again, more growing pains for expansion of this particular statute. And the court also hoped to avoid fostering, quote, vexatious litigation, end quote. The idea being that if you allow a complaint to stand beyond a motion to dismiss for this reason, it can create settlement pressure on a party, even if they've done absolutely nothing wrong. And those of us who've been involved in lawsuits know that there's settlement value just by filing a lawsuit. The court doesn't want to countenance that type of pressure, knowing that there's no basis for the underlying case. Also, the court points out the fact that, what is an offeree? It's vague. It could be subject to open-ended discovery forever. Is it everybody who reads a newspaper? Is it anybody who heard a speech? So at the end of the day, the court reins it back in, holding that 10b-5 is only available to purchasers in a civil suit. I also want to point out some important dicta if you look at note 1 on page 641, our authors point out the fact that 10b-5 may be used in combination with or in lieu of other securities law remedies. For instance, the proxy rules that we talked about before. Which brings us to the Ernst & Ernst versus Hochfelder case on 641. This is another U.S. Supreme Court case, this one from 1976. So I can't call on any of you to give me the facts, which I'm sure you're thankful for, but I'll kind of cut to the chase here. What was going on here was there were some false statements that were made by Mr. Ney in order to induce investors to invest in some non-existent, quote, escrow funds, end quote, essentially fraud to induce investment based on collateral or capital that didn't really exist. Ernst & Ernst was one of the large accounting firms at that time, and the plaintiff sued Ernst, claiming that they failed to detect fraud at the company, which was called First Securities. And obviously, Ernst & Ernst was not the issuer, First Securities was. And so it was arguably a stretch to find them liable under 10b-5 for failure to detect the fraud. Now, might they have been guilty of negligence in their auditing function? Sure. That's a different law. That's essentially the law of negligence as it relates to what they were charged with doing. But they were sued for aiding and abetting 10b-5, a violation by Mr. Ney. The allegations essentially charged, I would characterize it as a negligent nonfeasance or failure to act based on what the plaintiff claimed was failure to use appropriate auditing procedures. Again, that sounds like negligence to me. How did the court deal with these allegations? Well, if you've read the case, hope you have, you'll see that the court focuses on the scienter element that I talked about before, basically determining the statute 10b proscribes intentional misconduct, and then taking the position that negligence is not intentional, and that seems obvious, but that was the court's statement, basically finding no 10b-5 liability for aiding and abetting a violation of 10b-5. And if you look back, we'll get into this more in a few minutes, but if you look back at the actual language of Rule 10b-5, you'll see that requirement of a device, a contrivance, something that implies a conscious act on the part of the actor to engage in the bad conduct, aiding and abetting. Negligence, as it were in this case, is not going to rise to the level of allowing 10b-5 liability on that third party. The final case on this slide I want to look at is the Santa Fe Industries versus Green case on 643. What was going on here? Well, this was a case where there was a transaction that was being discussed that's described as a Delaware short form cash out merger. We've talked about what those are a little bit before, but essentially it was a transaction where the company was going to merge with another company. Shareholders were either going to receive shares of the merged entity or cash. And as we've talked about before, we'll talk about it more later, this, of course, is subject to shareholder approval. The plaintiffs in this case brought an action claiming alleged unfairness of the merger transaction. They brought it under 10b-5. Now, we know that they could have brought it as a breach of fiduciary duty action against the directors. That's always available, and we've talked about that a lot. But they bring it under 10b-5. The lower court in this particular case, oh, I'm sorry, let me go back just to frame the issue a little more clearly. Is a fully disclosed transaction that allegedly breaches a fiduciary duty to the shareholders, actionable under 10b-5. So this was a fully disclosed transaction. Can it still be addressed under 10b-5, which, as we know, has this concept of deception or fraud baked into it? What did the lower court do in this case? They basically held that a claim of breach of fiduciary duty to minority shareholders in the pricing of a merger stated a claim under 10b-5. There was no need to show misrepresentation or non-disclosure. The case gets appealed to this court and the U.S. Supreme Court. And what does the court do? It reverses. And let's talk a little bit about how it got there. First of all, the court cited the Ernst approach of looking to the statutory language in 10b or 10b-5, and it finds that the alleged conduct was not manipulative or deceptive, which is at the heart of 10b-5. There's no requisite scienter. The transaction was fully disclosed to the shareholders. They weren't deceived in any way, shape, or form. They simply don't like the fairness of the transaction. As I said before, this is could be a state court cause of action. And then the court looked at some cases of real deception where there have been false information given regarding pricing or false information regarding the intention of the parties after the merger, for instance. Here, this was a fully disclosed transaction. And the court says that the fundamental purpose of the 34 Act is to implement a philosophy of full disclosure. And once full and fair disclosure has occurred, the fairness of the terms of the transaction is, as the court says, at most a tangential concern of the statute. Congress didn't intend to create a federal cause of action for breach of fiduciary duty. That is a state court remedy, and of course that's what we discussed 2 weeks ago. The court goes on to say, corporations are creatures of state law, and investors commit their funds to corporate directors on the understanding that, except where federal law expressly requires responsibilities of directors with respect to stockholders, state law will govern internal affairs of the corporation. That confirms what we know already. Corporation law is first and foremost state law, and aside from these special federal laws that apply to federally traded companies. I would suggest that this is the right decision. Let's see here. Also, if you want to look at 644, this does harken back to a reference we had to the Weinberg versus UOP case, which, as a matter of state law, imposes certain duties of intrinsic fairness when they're interested in a transaction. We've talked about that before. This brings us to the Enron case from 2002. I'm not sure if you remember that case or not. Some of you are probably way too young to have remembered it, but it was an energy company that was publicly traded and made certain representations to investors based on their rather creative accounting practices, which, when they were discovered, the stock price for the company collapsed, and many investors lost lots of money. This was despite the fact that there were 33 Act and 34 Act compliance requirements on the part of this particular issuer, and the court basically was faced with a class action lawsuit brought by investors to achieve a remedy under 10b-5. Was this a direct or a derivative action? I hope you agree that it's a derivative action. This was brought in the name of all shareholders who would have been affected the same way, and therefore the recovery would have come to the corporation as having been harmed by the actions of these parties that we're going to talk about. The class action brought by the purchasers of Enron stock alleged false statements by banks, securities firms, and law firms. The company had massive debt, which they had disguised through the use of, quote, special purpose entities and, quote, off-balance sheet accounting. They had basically been playing games with the books to underdisclose the true magnitude of debt the company had. So you might ask, why did the plaintiffs sue these particular players, the bank, the securities firms, and the lawyers? I would say the answer is very simple. Enron was defunct, and their house of cards collapsed. There was no one else to sue. So they came up with these rather creative theories to sue these, what we will call secondary players. So what did the plaintiffs allege with respect to these secondary player groups? The accountants, number one. Basically, they're accused of fraudulent accounting practices, lack of independence. They'd been involved in representing Enron and its principals and its officers for a long time and didn't really distinguish between the role of the corporate counsel and the role of the individual counsel to the officers and directors. As an auditor, the accountants should have been, as the auditor of a public company, the auditors should have been the public watchdog for the company, and they fell down on the job. They should have consolidated results so that the investors had a fairer picture of what was going on. There was also an acquiescence in Enron's refusal to take a $51 million downward adjustment once these shenanigans were discovered. And of course, the accusation is that the accountants were motivated by fees more than anything else. With respect to the banks, the argument was that they allowed loan transactions to be disguised as sales transactions. And as we know, it's one thing to borrow money, it's another thing to sell product and get money. So by not disguising them, by not showing them as loans, they were fraudulently understating the actual debt of the corporation. The banks also were involved in securities regulation reports. That is, they had divisions of their banks that researched companies and sold that advice, publicly available information, to investors and to portfolio managers. They were accused of making false analyst reports. And then finally, the lawyers were accused of falsifying SEC filings under the 34 Act. That would be the 10Q, the 10K, the registration statements. They were also accused of structuring of these bogus special purpose entities, providing legal opinions that they knew were false, and having some conflict of interest issues because they were one of the parties accused of wrongdoing. They were also investigating that wrongdoing. So what did the court do about this? How did the court handle this? If you look at 646, they basically said that scienters properly pled in this case. Said the allegations must demonstrate that defendants knowingly or with reckless disregard stepped outside the boundary of legitimate professionally acceptable activities, performing material acts to defraud the public. Now, what's significant here is that they are not the primary violator. They are not the issuer. The issuer is the one who'd be in a position to make a false statement. So how do we charge these secondary actors with direct liability under 10b-5? Remember, we just had a case, the Ernst & Ernst case, that said there's no aiding and abetting liability. And in that case, it was based on the fact that it appeared to be simply negligence on the part of Ernst & Ernst. This is a step further down the road where we are going to try to find directly attributable scienter against these secondary players, suggesting that they're culpable under 10b-5. So in terms of the banks, and this is a motion to dismiss, the court holds that the plaintiff has stated a primary violation against the banks because they stated the requisite scienter. In terms of the law firms, the court again says yes, since they, quote, effected the very deceptive devices and contrivances that were the heart of the alleged Ponzi scheme, end quote. The court has no problem finding direct liability against the law firms. And in the case of the accountants, the court looks at a strong inference of scienter, and they base it on emails, internal memoranda that, quote, reflect the accountant's knowledge and intent to continue in the fraudulent scheme. Not as direct as the other two parties, but again, they're able to find enough scienter, in this case, even circumstantial scienter in the case of the accountants, to find liability against the secondary players. The takeaway from it is there is 10b-5 liability for whomever can be found to have the requisite scienter and the requisite bad act, and not just the issuer of the shares. That was a takeaway from this case. The first code is the letter M. The first code is the letter M. We've spent a lot of time talking about legal and regulatory systems that control the dissemination of information to shareholders. Proxy statements, annual reports, stock registration statements, management and discussion and analysis sections of different reports. All of these systems are intended to facilitate the orderly dissemination of information to the marketplace, in furtherance of the goal of all investors receiving the same information about a company at roughly the same time. This is sometimes referred to as the efficient capital market hypothesis. If that is the case, if everyone's getting information at approximately the same time through this orderly system of information disclosure that we've talked about, then the decision to buy or sell securities should be based on a company's business fundamentals and not on secret information that is not adequately digested by the market. What do we mean by fundamentals? What are we talking about? For instance, what are the producer's cost of goods? Does it produce goods or services that are defect-free? Is its selling price competitive? What are its profit margins? Does it utilize best business practices to keep it out of court? Etc., etc. The insider trading cases involve the situation in which important, I'll call that material, information about a company finds its way into the marketplace outside of the regulatory systems of disclosure we've discussed for publicly traded companies, where specific information having the ability to impact the trading price of securities is disseminated to and used by certain market participants to the exclusion of others. This type of activity is generally referred to as insider trading. That is, the use of non-public information by a particular trader for his or her personal benefit. I would submit that this is the antithesis of the paradigm posited by the efficient capital market hypothesis. Here are the legal and policy questions that come up in this area. What kind of information can influence the trading in a particular security? What is insider information or inside information? Is it ever okay for an individual to trade on material non-public information? How have the courts addressed the regulation of trading on material non-public information? Have the legal standards changed over time? If so, how? Why should we care whether a particular individual trades on inside information? What are the policies of which we should be concerned? As opposed to many of our prior cases in this semester, which are state court decisions, the cases in this section are primarily those of the U.S. Supreme Court, since we are dealing primarily with federal law. At the end of the day, Katie Roberts, the defendant, was found to have violated the law and under 10b-5. And so we have a rather simple explanation or a simple analysis of a relatively simple case to establish the principles that we just mentioned. The next case I want to talk about is the Chiarella versus United States case. This was a Supreme Court case from 1980, and this involves a printer who worked for a financial printing house back in the day when parties to large transactions typically are required to obtain shareholder approval. That shareholder approval is typically obtained through a proxy statement that's sent out to the shareholders asking them to approve a measure. It's on a corporate agenda for a meeting, and those documents, those prospectuses, those proxy statements used to be typeset manually back at this time. And Chiarella would see these proxy statements, prospectuses coming across the printing floor. They did have a policy of blacking out the names of the parties, knowing that if that information got out early, it might affect the trading price. But nonetheless, he was able to figure out the name of the target company and bought some of the shares and traded on them and made a decent profit. Did he steal the information? That's a good question. Perhaps he did, perhaps he didn't. Was he an insider in the classic sense? Typically, insiders are officers, directors, and employees of the issuer. And the answer there is no. Now, we've talked before about why the announcement of a takeover drives the price up, and that's the market mechanism that he was anticipating when he purchased shares before the announcement was made. So in this case, the SEC filed civil charges against Chiarella, which resulted in a consent decree, which is basically a settlement agreement, and he repaid the profits that he got through this trading. However, the SEC also is entitled to criminally indict for these same laws, and they did indict him under 10b and Rule 10b-5. He was convicted at trial, and it was upheld by the appeals court. It comes to the Supreme Court where it's reversed. And the question is, how did it get there? How did it happen? How did it get reversed? The court starts out with the basic statute, 10b and Rule 10b-5, as the court did in Ernst & Ernst, and notice that statute doesn't really address the same issue that we had in the classic insider trading case. They looked at the Katie Roberts case, which of course imposes the duty to refrain from trading only if there's a particular relationship that the trader has with the issuer of the shares. In other words, unless the trader is someone who's been specifically entrusted with information. In the case of Katie, it was a broker. It might also be a director or an officer who is under a fiduciary duty to act only in the best interests of the corporation. And of course, trading ahead of the market is not in the best interests of the corporation. So according to the Chiarella court, this failure to disclose or to trade or refrain from trading only arises to the level of a 10b-5 liability where there's a recognized duty to disclose or refrain from trading on the part of the trader. In this case, the trial court instructed the jury that the trader owed a duty to everyone, to the market as a whole. And this court sees that as an overly broad instruction. On the appeals case, this court characterized the appeals theory as follows. Quote, the use by anyone of material information not generally available is fraudulent because it gives certain buyers or sellers an unfair advantage over less informed buyers and sellers, end quote. Here, there's really no recognized duty on the part of the printer. And the court goes on to say that, quote, neither Congress nor the SEC has ever adopted a parity of information rule. What do they mean by that? Basically what they mean is if you look at 567, there's a discussion of the court's what perceives a fallacy of the appeals court rationale. There will always be people who have better information than others. There are security analysts who legitimately go out and do their homework, perhaps even better than the company does its homework about itself. And as long as it obtains that information lawfully and doesn't use it in a way that's going to hurt the corporation or its shareholders, they'll have better information. So the lower court basically held that because Chiarella had better information, he was liable under 10b-5. This court says no, it's not just that. It's not just having better information. They say that, quote, we hold that a duty to disclose before trading or to refrain from trading under 10b does not arise from the mere possession of non-public market information. What's important is whether that information was obtained in breach of a duty to the source of the information. And in this case, the SEC didn't allege a violation of Chiarella's duty to his employer. They didn't really allege a breach of any duty to anyone. They simply convicted based on the fact that he had bad information. We have a dissenting opinion in the case that's pretty strong by Justice Berger. He was of the opinion that misappropriation of non-public information, and by the way, he considered this to be misappropriation, should trigger absolute duty to disclose before trading or to refrain from trading. If you look at page 659, essentially he's proposing a new rule. And the way he gets there is by looking in the language of 10b-5, says that if any person is involved in, quote, any fraudulent scheme, end quote, that this misappropriation provides the requisite scienter to fall under 10b-5. This became known colloquially as the misappropriation theory of insider trading. About 4 months after Chiarella was decided, the SEC, by its rulemaking authority, adopted 34 Act Rule 14E3. You look at page 664, there's a nice synopsis of what the rule says. Essentially, imposing a duty of disclosure under 14E on any person who trades in securities, which will be sought or being sought in connection with a tender offer. That's one company offering to buy the shares of another company. Well, that person is in possession of material information which he or she knows, has reason to know is non-public, and has been acquired directly from the offering person, from the issuer, officer, director, partner, employee, on behalf of that issuer. Now, it goes on to say that the only time this becomes operative is if a person is actually trading on the shares about which they obtained information. So it imposes a specific duty to disclose that they have this information or to abstain from trading in the shares. And if you look further down on 664, you see a number of examples of how this rule might actually play out. Code 2 is the letter A. Code 2 is the letter A. U.S. versus O'Hagan is the follow-up case in most textbooks from Chiarella. This is a 1997 case in the U.S. Supreme Court, which a lot of people consider to be Berger's vindication. So what's going on in this case? As the text tells us, O'Hagan is a lawyer at the firm of Dorsey and Whitney in Minneapolis, and his firm is representing Grand Met in connection with the acquisition or combination with Pillsbury. He didn't actually work on this transaction. His firm worked on it, but somehow he learned information about the pending deal. He purchased some shares at the pre-announcement price and made $4.3 million. You'll see that he was charged by the SEC with insider trading and essentially couching it in terms of defrauding his firm by violating a duty of confidentiality to the firm. And you'll see a description of all the other specific counts, including money laundering and a number of other causes of action. He was convicted at trial. The Court of Appeals for the Eighth Circuit reversed all of those convictions, basically saying that although Justice Berger had advocated the adoption of a misappropriation theory in the Chiarella case, it was a minority view, and therefore you can't convict someone based on misappropriation theory, at least not right now. The appeals court also took the position that the Commission's adoption of Rule 14E3 that I mentioned a few minutes ago exceeded its rulemaking authority, since it doesn't technically require a breach of fiduciary duty, which had been one of the established principles coming out of Katie and Roberts, and therefore they reversed the conviction at the appeals court level. It gets appealed again to the Supreme Court. If you look on 667, where the discussion begins, there's a good explanation of the difference between classical theory of insider trading, that is, one that's involving officers, directors, or other permanent insiders of the corporation, and perhaps even some service providers to the issuer, but also this idea of misappropriation theory, as discussed in Berger's dissent in Chiarella. How does this court fit misappropriation into 10b-5? Well, taking a page from Berger's dissent, they basically see the theft or misappropriation of material inside information as equivalent of the requisite deceptive act and accompanying scienter that's referred to in 10b-5. As for the argument, the appeals court holding that the commission exceeded its rulemaking authority under 14E, the court basically disagrees with the appeals court, holding that the commission may prohibit acts not themselves fraudulent under the common law or 10b if the prohibition is, quote, reasonably designed to prevent acts and practices that are fraudulent, end quote. In other words, the SEC can prohibit acts that are not themselves fraudulent as long as they're reasonably designed to prevent fraudulent acts. That's 672. What they're reading there is an expansion, essentially, of 14E3, a rational, necessary expansion in order to give effect to the intent behind Section 12B. After O'Hagan, we now have two theories of insider trading. First one, classical, where the wrongdoer is an actual insider. Second, misappropriation, where the wrongdoer is not a traditional insider, but has in fact breached a duty to the source of the information, breached a duty to the source of the information. The next case I want to talk about is Dirks versus SEC. This gets into the interesting issue of what's the liability of someone to whom information is tipped by someone who may have obtained it inappropriately. In other words, kind of a second generation removed from the source of the information. This discussion starts on page 683 in case you're following along with the text. Dirks is a 1983 case from the U.S. Supreme Court. involving Mr. Dirks, who is a security analyst. Let's call him the Tip E. He is told by a former officer at Equity Funding, which is the insider or the tipper, that Equity Funding's value was overstated due to some fraudulent corporate practices or something, some malfeasance going on. Dirks conducts his own investigation into this because he is a securities analyst, and that's what these folks do. They're financial detectives. Dirks, tells a Wall Street Journal reporter of the fraud allegations, and the Wall Street Journal writes its own article and publishes the story. Dirks also discusses his investigation results with some investors informally. I would call these the sub-tippies. Now, subsequently, when all of this information was published, the stock price went south. Now, importantly, Dirks did not trade on the information. He didn't profit directly from it, nor indirectly, as far as we can tell. He's charged by the SEC under 10b-5 with aiding and abetting. If you look at page 684, it talks about that. Aiding and abetting stock manipulation, since those who learned of the fraud allegation from him sold their shares, presumably before the stock went down, thereby avoiding a loss. Dirks gets censured by the SEC. What does this mean? It means it's a professional reprimand. Securities analysts are licensed under the securities laws. So they have some regulation that governs them, and they have a regulatory body that oversees them. And so censure was the penalty he had to face. The appeals court affirmed the censure. It comes to the Supreme Court, and the Supreme Court reverses it. In other words, finding that he didn't violate 10b-5. How did they get there? How did the Supreme Court get to the point where they reversed the lower court? Well, again, they restated Chiarella, that there has to be some kind of a duty, and by now we also have the O'Hagan case with that same principle. Tippies generally don't have a duty. They're typically receiving this information with no strings attached. Someone can just simply share it with them, or perhaps they even just hear someone talking about it informally. The SEC had taken the position that when a tippee receives inside information from an insider, the tippee inherits the insider's duty to disclose before trading. The court basically said, again, we've heard this before, according to this court, quote, the SEC's theory of tippee liability appears rooted in the idea that the anti-fraud provisions require equal information among all traders, end quote. The court again rejects that idea, as they had before in Chiarella, and they say, we have reaffirmed today that a duty to disclose prior to trading arises from the relationship between the parties. First and foremost, the relationship between the parties, and not merely from one's ability to acquire information because of his position in the market, in this case, because they're a securities analyst. And they go on to talk about the fact that if they were to hold otherwise, then securities analysts would be out of business, even if they obtained information without violating any duty they had to the source of the information. And securities analysts are necessary for a vibrant securities market, informed traders, etc. Now, does this mean that there's no such thing as tippee liability under 10b-5? No. For instance, if an insider recruits a tippee to trade on the insider's information, that would create some liability on the part of the tippee. But the court states its rule of tippee liability fairly clearly on 688 at the top. It says, quote, thus a tippee assumes a fiduciary duty to the shareholders of a corporation not to trade on material non-public information only when the insider has breached his fiduciary duty to the shareholders by disclosing the information to the tippee, and the tippee knows or should know that there has been a breach, end quote. In this case, the first step, did the insider's tip to Dirks breach his fiduciary duty to the corporation? We don't know, unclear. Second step, did Dirks have reason to know that the executive was breaching his fiduciary duty? No. The last case I want to look at in this area is United States versus Newman, the Second Circuit case from 2014 on page 693. This is an appropriate follow-up to the Dirks case, focusing on TIPI liability for insider trading. So what's going on here? Again, we have a securities analyst working at a hedge fund, which is a mutual fund buys stocks and packages them together and obtains money from investors. He received material non-public information from clients and then shared the information with portfolio managers within his company who traded on the information. So securities analysts typically work in companies that actually assemble packages of securities to sell to investors. So I'm not sure whether they had some sort of protection in place between the securities analyst section of the company and the portfolio manager section of the company. But in this case, the security analyst shared the information with the portfolio manager. Newman and Chasson were tippies, using Dirk's terminology. So what's the issue here? The jury instructions given at the trial, which resulted in guilty verdicts for both the defendants, was purportedly erroneous. The trial court instructed the jury that they could convict the tippies under 10b-5 without finding that the tippee knew the insider disclosed confidential information in exchange for a personal benefit. Now, if you look at 694, you'll see that the tippies were 4 levels removed from the inside tippers in this case. There wasn't any actual evidence that the tippies knew that they had received information in breach of a duty in exchange for a personal benefit to the tipper. And the SEC's argument was, well, as, quote, sophisticated traders, they must have known, end quote. And so the idea being that these folks must have known that at the top of the food chain, someone was receiving a benefit for disclosing this non-public information. If you look at 696, I would submit this is a really excellent, I'll call it insider trading in a nutshell, which summarizes everything we've talked about so far. You might want to bookmark that particular page. I think it's a really, really helpful summary of where the jurisprudence had developed to by 2014. So what's the rule that comes out of this? If you look at the top of page 700, we have a nice summary by the court. First full paragraph. In sum, we hold that to sustain an insider trading conviction against a tippee, the government must prove each of the following elements beyond a reasonable doubt. That the corporate insider was entrusted with fiduciary duty, okay. The corporate insider breached his fiduciary duty by disclosing confidential information to a tippee in exchange for a personal benefit. Number 3, the tippee knew of the tipper's breach. That is, he knew that the information was confidential and divulged for personal benefit. And the tippee still used that information to trade in the security or tip another individual for personal benefit. This provides some clarity to this area of law in terms of tippee liability, and I think it's a great summary that you want to keep track of. Moving beyond our initial exploration of the development of 10b-5, and then our look at insider trading, this next subsection of the chapter addresses securities fraud in a broader, shall we say, market context. The first major case I want to look at is Basic v. Levinson, a Supreme Court case from 1988, which is a classic that's still cited today. This case addresses the issue of materiality as it relates to trading in securities and disclosure of information, and something specific we haven't seen before called the fraud on the market theory. Combustion expressed interest in acquiring Basic, which was the target in this case. Basic made a series of 3 public statements denying merger negotiations. Basic then asked the New York Stock Exchange to suspend trading. This typically is what a company does when it's on the verge of a announced transaction in order to prevent a buying or selling frenzy in the stock. After they suspended trading, Basic accepted Combustion's offer for the merger. The plaintiffs brought a class action alleging 10b5 damage resulting from the 3 statements, alleging that they were false, since Basic was in fact negotiating when it said it wasn't. How did they allege they were harmed? Well, plaintiffs sold their stock after the first denial of negotiations. Presumably, when the deal was finally announced, the stock price went up. In other words, they felt they were misled and they made a trading decision based on that. What did the district court do? Well, the district court granted summary judgment for defendant Basic, holding that any of the misstatements were immaterial. And on appeal, the appeals court reversed, rejecting the district court's holding that preliminary merger negotiations were immaterial. In other words, that preliminary merger discussions were material. And they basically justified it like this, saying, quote, once a statement is made denying the existence of any discussions, even discussions that might not have been material in the absence of a denial are material because they made the first statement untrue, end quote. Kind of like that idea that the lie is worse than the subject of the lie sometimes. The appeals court recognized this fraud on the market theory to create a rebuttable presumption that plaintiffs relied on defendants' material misrepresentation. And the Supreme Court then grants cert. Code 3 is the letter M. Code 3 is the letter M. So the Supreme Court discusses 2 major issues here. The first one is, what is material as it relates to preliminary merger discussions? Now remember, we're talking about a merger transaction here. This is not insider trading. This is a statement that could affect the trading price of shares. So the first issue is materiality. And then the second issue is, did the court below properly apply this presumption of reliance in certifying the Rule 23 class, that is, in applying the fraud on the market theory? So in terms of materiality, the court looks at the TSC Industries versus Norway case for the proposition that, quote, an omitted fact is material if there is a substantial likelihood that a reasonable shareholder would consider it important in deciding how to vote, end quote. And we've seen this language before. The problem is that TSC Industries is more difficult to apply when dealing with contingent effects, contingent events like a possible merger transaction. The plaintiffs had suggested an agreement in principle test, which is good since it doesn't bother shareholders with lots of little details of the transaction and allows the company to preserve some confidentiality and is essentially a bright line in the sand that allows for easier analysis. And this is what was proposed by the plaintiffs. So how does the Supreme Court respond to each one of these? Well, as to the idea of agreement in principle and the argument that it doesn't bother shareholders with lots of little details, the court basically said, look, shareholders are not nitwits. They can understand the nuances. There might be something less clear than an agreement in principle. As to the argument that it allows the company to preserve some confidentiality, the court finds that irrelevant. And as to the benefit of a bright line in this particular type of transaction, the court basically points out that it's oversimplistic. It doesn't really work in fact-intensive contexts. In other words, the court rejects this agreement in principle rule of materiality. So how would we describe the test that the court did in fact adopt? In the context of a merger transaction and statements made by an issuer about a possible transaction, the court adopts the TCS probability and magnitude test. In terms of probability, you know, are there indicia of interest, board resolutions, letters of intent that have been signed, contracts that have been signed. In terms of magnitude, what are the relative size of the entities? What are the potential premiums that are going to be realized above the market in the context of this particular transaction? On the issue of materiality, what does the court do? It remands for analysis under the probability and magnitude test that it recognized for this particular issue. In terms of the reliance issue and fraud on the market theory, if you look at page 719, there's a really decent description of the theory itself, and I'm not going to read it. You can read it yourself. The theory assumes efficient capital markets, as we've talked about before. And the problem is, how do you show reliance by an entire class of plaintiffs, in this case, purchasers of stock? How do you prove individualized reliance? The district court found that the presumption of reliance created by the fraud on the market theory provides a practical resolution to the problem of proving reliance in a class action context. What does the court mean by that? What did the court mean by that? Well, if you look at Federal Rule 23, the prerequisites for a class action are that, number one, the class is so numerous that joinder of all members individually is impracticable. There are questions of law and fact common to the class, and the claims and defenses are typical of the plaintiffs, named plaintiffs are typical of everyone in the class, and that the interests of the representative parties will fairly and adequately protect the interests of the class. In other words, there's this commonality requirement, both in terms of the harm and reliance on the statement. The defendants had argued that the fraud on the market theory eliminates the causation element provided by reliance. This court says, in light of the reality of modern trading, as they say, millions of shares changing hands daily, 10B's reliance requirement has to kind of get with the times and realize that we need a mechanism to address the possibility of this wide-reaching fraud. And in the context of the efficient market hypothesis we've been talking about, at the appeals court level, they talked about this presumption of reliance. And this is essentially a function of the integrity of the market under the efficient capital market hypothesis. If you look at page 720 at the bottom, there's a good description of that. The court goes on to say that Congress premised that the market price for shares traded on well-developed markets reflects all publicly available information is valid consideration, and the fact that the material misrepresentations can have the effect on the entire market at the same time based on the widespread availability of the same information to everyone. One wrinkle in that fabric can cause an immediate reaction in the markets. Now the court goes on to say that this presumption is rebuttable if you can sever the link between the alleged misrepresentation and the price received by the sellers. In other words, if it can be proven that the plaintiff was not privy to the information, for instance. So the way I would sum up what the court did with these two issues is the court agrees with fraud on the market, including its presumption mechanism, but disagrees with the materiality standard, and therefore the case was remanded for that purpose. We'll see on 722 there's a dissent, Justice White's dissent, that the court chose to include in the opinion. And why did they include the dissent? Well, for one reason, this is a plurality decision. 5 of the 9 justices did not sign on. And he also makes some decent points. Fraud on the market theory is a mere babe. It's brand new theory. We really don't know that much about it. And of course, he also says that we know 10b-5, that's pretty straight ahead stuff if you look at page 723. And finally, he points out the fact that this court is really outside of its area of competency when it starts to talk about these types of market economics. White makes a few other points that I think are important. He criticizes the court's statement that investors are entitled to rely on market price as a reflection of its true value, mainly because the whole purpose of being a educated trader is to try to get the best information you can. And therefore, those who believe that they have better information, that's what's being disseminated, have proven essentially that the reported market price doesn't reflect the value of the company. Number two, he points out that all of the plaintiffs actually made money on the sale of their basic stock, albeit perhaps not as much as they wanted, but they all made money. Number three, there's no evidence that the three statements were made with any intent to manipulate or influence stock price. Remember, the scienter requirement has been part of what we've been talking about throughout our discussion of 10b-5. And finally, Justice White sums up his opinion by saying, quote, "I cannot join the court in its effort to reconfigure the securities laws based on recent economic theories to better fit what it perceives to be the new realities of financial markets. I would leave this task to others more equipped for the job than we." End quote. However, it was a dissent, and fraud on the market theory is recognized today. Code number 4 is the letter A. Code number 4 is the letter A. I'm going to move on to the last topic in this section, where we're talking about not necessarily fraud in connection with sale of securities or insider trading, but they raise the issue of what are the rules that apply when a majority shareholder decides to sell its stake in the company. To whom is a duty owed, if anyone? The first case is DeBond versus First Western Bank on page 731. So in this particular case, the bank sells stock to a individual who ends up being a scoundrel, a corporate raider, as it were. The way it happened was 70 shares of the founder of John Incorporated ended up in the hands of the bank as trustee of his personal trust. And the bank ended up owning the shares as his trustee. Minority shareholder DeBond holds 20. Another shareholder named Stevens owns 10, but the bank, stepping into the shoes of the founder, has 70. Now, the bank decides to sell the shares because the bank isn't necessarily aligned with the shareholders, the minority shareholders. They're simply a financial fiduciary, as it were, holding as a trustee. A gentleman named Madison, the bad actor here, makes an offer which is accepted by the bank. He pays some securities as a down payment, leaving a $200,000 balance for the rest of the shares. He pledges the stock he's buying as collateral. That's what we call a leveraged transaction, where you're using the assets you're buying to secure borrowing to buy those same assets. Rather circular. He also agrees to also pledge the corporation's assets once he's in control of the company. In other words, to give the bank a security interest in everything. The bank officer, Furman, fails to disclose these facts to the minority shareholders, who presumably would want to know what's going on, and we'll talk about that in a minute here. The fact is that the bank should have known that the company would not generate sufficient after-tax cash flow to service the payoff of the balance, that Madison had 38 unsatisfied judgments against him and was party to another 54 pending lawsuits. And the bank really did not conduct any investigation of him at all. However, he made a good impression at the Jonathan Club, which seemed to make carry a lot of sway with the bank. So Madison ends up bleeding the corporation dry and eventually folds. Plaintiff DeBond, who'd worked for the company, is fired, and he files suit on his personal behalf and derivative action on behalf of the corporation. And the trial court fines for him. This court states essentially the principle that we have, the most important principle that comes out of this is regarding breach of duty of a controlling shareholder. The modern rule is, quote, in any transaction where the control of the corporation is material, that suggests that 70% is, the controlling majority shareholder must exercise good faith and fairness from the viewpoint of the corporation and those interested therein. This is essentially in connection with the sale of control to a third party. Sounds like fiduciary duty to me. And in fact, that is the rule that came out of this case, is that majority shareholders have a fiduciary duty to minority shareholders, despite the position some majority shareholders take that if I own the majority, I make all the rules and can do anything I want. That's not the case that comes out of this case and similar cases in most states these days. The bank owed a fiduciary duty to the minority shareholders. Instead, it basically committed what would look like a duty of care breach, a la Smith v. Gorkum. The trial court correctly determined that damages should be going concern value based on past earning power, and it was therefore not speculative. So this court affirms the bank is liable. If you take a look at note 1 on page 737, this states one of the ALI principles on this subject, their particular principle 5.16, basically states the general rule that any shareholder is free to dispose of shares whenever they want to, subject to any contractual agreed restrictions. But a controlling shareholder, they say here, has a certain duty of fair dealing with respect to the other shareholders. And they go on to say that if the controlling shareholder does not make disclosure concerning the transaction to other shareholders with whom the controlling shareholder deals, or if it's apparent from the circumstances that the purchaser is likely to violate the duty of fair dealing in such a way to obtain a significant financial benefit for the purchaser or an associate. This rule seems to impose, from a quasi-statutory standpoint, some of the same principles that were espoused by the court in DeBond. As to whether 5.16 has been adopted as statutory law in other states, I don't know. I assume it has been. I have not researched it yet. The next case I want to look at, and the last case, is the Perlman versus Feldman case on 739. This is a 1955 case out of the Second Circuit. Basically, a majority shareholder sells control and leaves the minority shareholder out. Again, Korean War, steel is in short supply, obviously high demand. Feldman was a major shareholder of Newport Steel, and he agreed to sell control to an outside syndicate of businesses that bought their steel. The price reflected what we call a control premium. What's a control premium? Typically, when a majority shareholder sells their interest in the company, they typically get more than just the straight per price share that's shown on the books of the issuing company. Why? Because by effectively selling control, they're selling to the buyer the right to make most major decisions over and above just the economic value of the shares. Conversely, when shareholders who have a minority stake sell their shares in a corporation, they typically get hit with something called a minority discount, meaning that the block of shares they're selling is worth less from a governance standpoint than just the economic value of the shares. Anyway, what was going on here was that the minority shareholder who was not included in the sale brought a derivative action claiming that sale of control of the market supply was a corporate asset. Remember, they were selling a significant chunk of the market um, for that steel, and therefore it was an asset that the minority shareholders should have shared in, and therefore have obtained the equivalent of the majority premium that the seller received. The court holds in favor of the plaintiff. Basically, the court charges Feldman as a fiduciary to the minority, quote, for in that capacity, he chooses and controls the directors and thus is held to have assumed their liability. According to this court, major shareholder has the same fiduciary duty as directors. It's kind of what we saw in the Bond case. And the defendants argued, of course, there's no fraud, just negotiation, that they could get for the best price for the shares. But the court goes back to the language we've seen many times now, the Semin versus Meinhard language regarding the duty of, quote, co-adventurers, quote, to one another. And, goes on to say that sale of corporate goodwill, which is a large chunk of what the majority was able to sell, plus the unusual profit consisting of the majority premium, requires, at a minimum, disclosure to the minority shareholders. If you look at page 742 at the top, you'll see encapsulated what the court's reasoning is. Essentially, this is what I would describe as a judicially imposed tag-along. What's a tag-along? A tag-along is a right that's sometimes given to minority shareholders to tag along with a transaction entered into by a majority shareholder. It's typically negotiated in a shareholder agreement. And in this case, the minority shareholders would have had an agreement with the majority shareholders saying, if you receive an offer to sell all of your shares, we have the right to tag along and be included in that sale. And conversely, there's a flip side of that is something called a drag along. If, for instance, the majority shareholder's sale of shares had been conditioned on him receiving the agreement of the minority shareholders to sell, he would perhaps have negotiated for the right to drag them along and force them to sell at the same price so that they couldn't hold up a transaction, as it were, to get something even better than what he was being offered. So this is what I would call a judicially imposed tag-along provision. Now, the dissent has a couple of different points here that I think are worth looking at. If you look at page 742 at the bottom, the dissenting opinion of Judge Swan has a couple of good points. First, he points out that the majority opinion is a little loosey-goosey in terms of exactly what role is imposing the fiduciary duty on the majority shareholder here. Remember, the majority shareholder was also a director. And we know that there are specific fiduciary duties for directors. The idea of fiduciary duty on majority shareholders we know exists, but it's certainly more vague and of more recent vintage than the idea of a director or officer's fiduciary duty. So Justice Swan has a problem with that concept as well. Okay, I need for each of you to email me at jkr@rusalaw.com, the address I've been using for everything. Email me the 4-character code from today's class. I need you to get it to me by midnight tonight. If you email that to me, I know you attended and actually possibly listened to and paid attention. All right, on Thursday, we're going to have an insider trading hypo. It's going to be one long fact pattern with a series of questions after it, maximum 25-word limit for each response. I will need for you to email your responses back to me by the end of the class period on Thursday night. And when I will send the hypo out to you Thursday just before class time, and I'll ask you to acknowledge that you received it so that I know everyone got it. And if there are any questions that come up between today or the time you're viewing this series of PowerPoints and Thursday regarding the materials that we're looking at, please email me, call me, text me, and I'll be happy to answer any questions you have about this. Review your notes, review the slides, make sure you read the text that I've talked about. And as before, with the instructions to the hypo, pay close attention to exactly what I'm asking you to do. That's all for now. Good luck.